All right, welcome everybody to Lunch with Liz. Thanks for coming to hang out with us for the next 45 minutes to an hour or so. Um, for those of you that have been in these before, I normally have my trusty assistant Vicky handling the admin side of it, so you'll just have to bear with me as I am the one letting people in as well as the one chatting. So anyway, welcome to Lunch with Liz. You may have guessed by now, I am Liz Moneymaker. I'm your hostess for these monthly Ask the Lawyer programs. Um, I do estate planning, so think things like wills and trusts, powers of attorney, and I do probate and trust administration and Medicaid planning. Those are my main practice areas. Been doing it for quite a while. Right now, my only office is in St. Petersburg, Florida, but I do service all of Florida for those types of things. I started Lunch with Liz. Gosh, we're going on almost maybe we're over 4 years now. And I started it because I saw so many issues with just misinformation out in the community, and I wanted to have a way to address this misinformation so that people could actually ask questions. I could have just written a blog. I could have just had, something where I just get on and talk and post it. But making sure that you have an opportunity to ask the questions to get clarification was really why I wanted to do it this way. So I always said whether I had one person or 100 on here, it didn't matter because I just wanted to be able to help in some of this misinformation, one person at a time. So how it works is today, anyway, I do have a special guest, and I'll have her introduce herself in a moment. But we're going to do some discussion about estate planning and how it intersects with divorce, custody of children, that type of thing. We're going to do some back and forth questions. You feel free to ask questions either during that process, and you can do it whether you want to come off mute and talk to me, or whether you want to throw it in the chat. There's a chat box at the bottom of your screen, and you can just type it in there if you want. We'll be monitoring that throughout the next 45 to 60 minutes of the presentation. You certainly don't have to come off video. You don't have to come off mute. You can just put the question in the chat if that's the way you want to do it. Um, Keep in mind that this is being recorded. It will be posted on my website as well as Ms. Feher's website next week. So if you know of anyone who wanted to attend but couldn't, they'll be able to watch this later. Again, if you have questions that you want to hear it again, you're going to be able to see it again next week. It'll be on our website. We'll post it on our socials. So today's topic is an intersection between divorcing and estate planning. There are a lot of nuances to this, and you may hear us say the lawyer answer of it depends. And if you ask us a very specific question about your very specific situation, you may get that really needs to be discussed in private with your attorney answer versus discussing it in front of everybody else. So with that said, before we get into the meat and potatoes of today, I do want to have my co-host today, Miss Kristina Feher, please introduce herself and let you guys know a little bit about her.
Thank you, Liz. I'm excited to be here. I actually share office space with Liz, so I've been watching in the background of all these Lunch with Liz's go on. So I'm excited to be invited, excited to chat with all of you. I am born and raised in St. Petersburg, here in Tampa Bay, and I practice primarily in the areas of family law and bankruptcy. So on the family law side, I handle everything from divorce, paternity cases where the parents weren't married. I also handle same-sex divorces. I handle everything from child custody. Custody is kind of an antiquated word, but a lot of us still use it. So custody as well as child support, and then also name changes. So adult name changes, minor children name changes, etc. On the bankruptcy side, I help individuals and businesses navigate their way through dealing with their debt problems. So that's really what I focus on. Outside of the office, I love to cook, I love to bake, and I have two four-legged furry friends, pups, Thena and Luna. So that's me.
Well, thank you. Thank you, Christina, for being here. And for those that kind of joined in late, I just want to reiterate, we're going to start this with Q&A between Christina and I to hit some of the highlights of some issues. You are free to ask questions either coming off of mute or throwing those into the chat. We can do the questions as we go along. We're also going to open it up at the end for questions, okay? So Christina, let's start. Why do you think that divorce is such a critical trigger for reviewing somebody's estate plan?
Well, I think that the most important reason is when you get divorced, that person that you probably thought was going to be the key person in your estate planning documents isn't anymore. A lot of times when you're married, you handle your estate planning documents. I list my spouse. That's the person who's going to be my personal representative. That's the person who's going to be my healthcare surrogate. Or, and now that you're divorced, they're probably not going to be the best person. And so, meeting with you, Liz, and reviewing the estate plan is kind of the best next step in kind of changing that now post divorce as to what you'd like your estate planning to look like going forward.
Right. And I think one of the things people forget about is the way real estate ownership can change post divorce. Can you hit on that a little bit?
Yes. So when you own real estate with your spouse, that is usually given the coveted tenancy by the entireties, or sometimes we call it TBE. That is the highest protection of real estate that you can have. When you divorce, your final judgment of divorce, on the day you get divorced, the judge stamps the final judgment. Congratulations, you're single. That real estate automatically changes now to tenants in common, which would be no different if you owned your real estate with John Doe. And so an estate plan can kind of fix that issue. Or if you received a quitclaim deed because you're the one who retained the home through the divorce, but that's probably not going to be the end all fix. So you'd want to meet with an estate planning attorney to say, okay, now that I'm divorced, now that the real estate looks like this, what are my options? Do I want to leave it to someone else? Do I want someone else to own this home with me? And so, Liz, my question to you would be what kind of are clients' options in that estate plan when they end up owning the home by themselves post divorce?
Let me hit the owning it together as tenants in common for a second, because I do handle post-death issues through probate and trust administration. And when this happens, when it's not dealt with people's estate plan, what can happen is, let's say you got divorced, now you own it 50-50 with your ex-spouse dies, his estate plan now sends that 50% to his brother, for example. Now you own that home 50% with this person's brother or whomever else that he may have left his 50% to. So that's one reason why that is really a high priority to deal with once you go through the divorce process. If you do have it quickly quit claimed and you're the only one that owns it, now you just need to go back to your original estate plan if you had one. And if you don't, get an estate plan that then says what happens to that property. Whether you're going to go with a will, a revocable living trust, or potentially a ladybird deed, so that it can eventually go to who you want it to go to. Make sense? Okay. So I'm going to move on unless anyone has any questions about that. The next issue we want to talk about is um, so if someone comes to you, Christina, and they're discussing divorce, at what point do you suggest that they talk to their estate planning attorney?
So, the best time to talk to an estate planning attorney is after you're actually divorced. A lot of your documents that have beneficiaries, like a life insurance policy or even a retirement account, is going to have that has a beneficiary designation, is going to look for what we call a life event in order to make changes. And filing a divorce does not make that life event. It's actually when, again, when that judge stamps that final judgment. So once you have the final judgment, you know you're divorced, that's going to be the best time to go ahead, make an appointment with your estate planning attorney, bring in the old documents if you have it, and kind of let's go from there and see what's changed.
Very good, very good. Now, I think this is a good place to talk about some things that automatically happen at the time of filing of a divorce. For those of you who have done your estate planning, you know that, well, especially if you're my client, you know that I consider two documents the most important estate planning documents, and they are the power of attorney for finances in the event that you're incapacitated, and the second is your healthcare, your medical documents. Florida statute says that immediately when you file for divorce, if you've named your spouse as the agent under your power of attorney, that is void. So that's good because that means, let's say that you and your spouse are amicable about this divorce. That means your spouse can't go use that power of attorney in a nefarious way, to take assets, to sell assets, that type of thing. But what that also means is it's the second person in line for the power of attorney that now is your agent. So we have some issues there. One, we need to make sure that there is a second person in the power of attorney line. And number two, we want to make sure that that second person is who you want, because you may have done that power of attorney 10 years ago. So that is one issue with what happens when you file for divorce. The rest of the documents, your healthcare documents, your will, your trust, things like that, those stay in complete effect until you actually get that stamped copy of the judge finalizing your divorce. So if your divorce goes on for a year or 2 years, you have this scenario where your documents are pretty much, I think the phrase that family law courts use is status quo. Am I correct on that?
That is, yes.
Yeah, yeah. So that is one of the issues that I see from the estate planning perspective, and why I appreciate it when a divorce attorney would send the client to me immediately, because we can take some actions to update the documents. We may not be able to completely disinherit a spouse pending the divorce, but we can make some changes to the documents that would potentially ensure that other beneficiaries would get more than they would have otherwise should you perish during the pendency of your divorce. So those are the important reasons why the two practice areas overlap so much, is because it is important for you to talk to one when you're in the middle of dealing with the divorce side of it.
I want to touch on that real quick too,
Yep.
Liz. And, I want people to know that divorce cases can take a while, unless you have a true agreement right at the outset. It is possible under normal circumstances for a divorce case to take a year, up to 2 years. I just received a final judgment in July for a case that had been pending since 2021. So it is possible for cases to take a while. And if you have that healthcare surrogate, I would think that the healthcare surrogate is pretty important to change as soon as possible if you're not in an amicable divorce. Because that's probably not the person you want making healthcare decisions. And also, there could be a conflict of interest there. If you're going through your divorce, deciding who's going to get assets, who's going to get what liabilities, and this person is also making financial decisions, or excuse me, healthcare decisions for you, that could be a problem. And so, certainly, then meeting with an estate planning attorney once the divorce is filed can help you get those ducks in a row.
Yeah. So I think to summarize the this particular part we're talking about is when you decide to file for divorce or when your spouse files for divorce, one of the first things you should do is also talk to your estate planning attorney so you can mitigate some of these issues. They can be part of your trusted team going through this otherwise very emotional process. Let's shift gears now, then, Kristina, and talk about something that neither you nor I have, other than the four-legged kind, and that would be children
Yes.
when it comes to divorce. I know through my process as an estate planning attorney, one of the things I always talk to clients who have minor children is who would you want to have guardianship of these children should you perish? That takes a little different tone, though, when the parents are no longer together, correct?
Correct. And, Florida courts, especially, and that's where I'm licensed, Florida. So, Florida courts will give deference to the other parent. So, if a spouse dies, the children will most likely go to the care and custody of the remaining parent. But there's always an asterisk, or as you mentioned earlier, Liz, it depends. Is that other parent fit? Are they incarcerated? Are there substance abuse issues? So while the default is the other parent, there could be some additional concerns or reasons that that would not happen. And then it's important to note that Florida does not recognize grandparents' rights. So, in many situations, and especially in this economic situation, it's possible that you have multi generations living in a home. And so, just because grandma is living in the home with the decedent and the grandchildren doesn't necessarily mean that grandparent is going to gain the custody. So, there are a lot of things that you need to do in the family law courts if you really want to solidify those legal rights.
What would you consider the best practice for that be? If you're
So,
divorced and now we have this person's doing their estate plan and that person is doing their estate plan, how do you try to make it as good for the children as possible?
in the perfect world, which is what lawyers love, the perfect world, even though the two spouses divorced, it would be great if you all could agree on who a guardian of the children would be in the event both of you passed away. And that's not completely uncommon for those things to happen that the both parents are deceased at or near the same time. And so, if there's any hope that you two can agree on a single person, that is going to be the best case scenario. And I know all attorneys would love that, even if you didn't agree that you are good partners to each other, that you both agree on who is a good guardian for your children.
Yeah. And is it helpful to have this in the will and in the separate writing? Like,
Yes, one of the things the court is going to look for is did both of you agree and how did you both agree? And so there is a document you can draft up. It does need to be notarized that you both consent as single individuals. So, not as a married couple. Now that you're divorced, you're doing this individually, but that you both agree to the guardianship of your minor children to this person or maybe this person, and then a backup is the second person.
excellent. Any other children issues when it comes to divorce and estate planning that you want to highlight before we move on
Oh
to?
my goodness. I feel like there's so many issues that could come up, right? So just because you name someone a guardian in your estate plan doesn't automatically override the other biological parent's rights. So it's important that if you are going to have concerns about that, that you speak with a family law attorney. Once the parent dies and you're concerned about the other biological parents' rights, you could do a petition in a family law court for temporary custody. It for whether that's a grandparent, whether that is a family friend, whether that's the guardian that you want them to do, but the court is still going to use those divorce words of best interests of the child or children. And so, is that person actually caring for the children? You can't just kind of swoop in once the parent dies, but has that person who's petitioning for custody of the children actively involved in the kids' lives? Are they doing the things and stepping into the role of the parent? So, having someone in line, making sure they know the routine of the children, and then also having them file is going to be important. And then making sure that they do know the best interests of the children factors, geographic viability, how close are they to the kids' school, how morally fit and physically fit is that person. And that talks a lot about, Liz, when you are picking someone to be a guardian of the child, are you picking someone who is young, in good health, physically fit, or are you deferring to a grandparent who could end up in a walker or in a nursing home? And so a lot of the best interest factors should be taken into consideration when a person is picking who that guardian would be.
Got it. That's excellent. And before we move on to the next topic area, which is going to be alimony and child support, we do have a question. Can someone file for divorce without a divorce attorney? I think the answer is
Yes.
yes. Yeah.
Yes, yes.
Yes.
So it's kind of like painting your house, is how I explain it to all my potential clients. You could go to Lowe's, Sherwin-Williams, buy the paint, buy the brushes, get the tarps, put on your overalls, spend a lot of time outside, maybe 2, 3 weekends, painting the outside of your house. You could do that. There is also a benefit, but a cost to having the professional hired to do that work for you. You get to sit inside in the air conditioning, which right now is a heaven sent, and you get to have a professional do it where they have all the tools, they know how to do it, and they can accomplish it more efficiently. The biggest concern or the biggest fear I have when people file for divorce themselves is you don't know what you don't know. And one of the big things about your divorce case is if you are not moving the case forward, it doesn't move. So there's no one saying, this is the next step. This is what you have to do. This is the hearing that you have to set. This is the notice you have to file. So sometimes those are the things that really stall out cases. And if a case stalls for more than 9 months, it can be dismissed. And so knowing that, knowing those deadlines, that's really what you're getting in exchange for hiring the professional. And I get it. Economics is hard. And so sometimes hiring an attorney is a difficult thing to do. The Pinellas County has two self-help centers, both at the downtown St. Pete Courthouse and the downtown Clearwater Courthouse. And both of those self-help centers provide forms and also provide legal advice on a very discounted basis. It's $1 per minute in 15, 30, 45, and 60-minute increments.
Mm,
And I find that that's a really great resource for people who can't afford an attorney or really want to try to file it on their own. And so that's a great resource. But yes, you can find that. And I know that the follow-up question is, does that change, does anything change with the estate planning timeline? No, but I think the question is going to be the same as, are you meeting with your estate planning attorney during the process so that you can kind of shore up those documents that you can? And then you still have to wait till you get your final judgment in order to make final changes. So the timing of estate planning wouldn't change, but the timing of the divorce case would if you're handling it yourself, because you might not be able to gauge how long or how short the case may be able to go.
perfect. Thank you. I hope that answers your question. If not, let us know. We'll circle back to that. So moving on to alimony and child support. And I know this from an estate planning perspective because I will get clients that say, I have life insurance, and I'll ask them who the beneficiary is. And they'll say, I've been court ordered for my ex-wife or something like that. Can you
Yes.
give us an idea of what this tool is used for?
Sure. So there are times where a spouse, through the divorce, is ordered to pay alimony or child support. Oftentimes, then, life insurance is used as the security to cover that payment throughout the life of whether it's the alimony payment or the child support payment. In 2023, alimony laws went through kind of a pretty big overhaul for Florida. And the two major changes were that permanent alimony was taken off the table. So, any divorce filed after 2023, you are no longer eligible to request and receive permanent alimony. What it did was it changed durational alimony, which was kind of the next available tier of alimony, into a much more mathematical calculation. So it provides that you can receive alimony based on how long you were married for a certain portion at a certain amount of net incomes. And so that really then becomes a big change because now we can calculate how much the total alimony award is. Before, when it was permanent alimony, it just kind of went on forever until the receiving spouse remarried or the payor died. Now we know, okay, if I'm paying alimony in this amount for 7.5 years, this is the award. So the life insurance is used to cover that award. So if the payor passes away, the recipient still gets those funds that they were ordered to receive as alimony or as child support.
Got it. And what happens if they don't do this?
If they don't do this, they have now created a pretty big probate problem for themselves. What the recipient spouse would then have to do is file as a creditor in the probate matter and hope that there are assets to cover that award, which then begs the question, are there estate planning things that you could or should do as the payor to either ensure there are assets or maybe not make assets available?
Got it. When I'm advising clients about how to care for children, so we're talking about minor children here, I usually use my vernaculars to control from the grave because you don't want a kid to just automatically get, 100,000 or more dollars. And when it comes to these types of life insurance that, let's say it's for child support itself,
Mhm.
is there a mechanism that this can be paid directly through a trust so that it can be used for the children? Or are we always having to allow the maybe not so friendly ex-spouse to control these funds?
So I think that the family law courts would not want it put into a trust
Hmm.
because there's a lot of public disagreement on this.
Hmm.
But you can't control from the grave how the parent uses those funds. And so even though it's going into the surviving parent's bank account, it's covering things like rent or electricity, but that's parent may also be using those funds to get their nails done or make a car payment. So there's not a lot of ability for you to say this money is only for little Susie's education. You can do separate money for that, but you can't control child support expenditures through your estate planning documents. The amount is set, that's going to go to the other parent, and you cannot control that through estate planning.
Got it. While I ask the people on here if there's any specific questions about alimony or child support when it comes to divorce and estate planning, let me ask you, Christina, any other critical issues you think we need to address regarding that topic before we move on?
One of the things that sometimes comes through divorce is who owns the insurance policy, right? And who's going to control that? And because you went through a divorce, there's probably a little bit of lack of trust between the two former spouses. And so if you have an insurance policy for child support, securing that child support award, that beneficiary really should be the other parent because at the end of the day, the money is for the benefit of the child. Now, of course, if the child isn't living with the other parent, maybe they're in a temporary custody situation or they're living with grandma, then grandma should be the beneficiary. But a lot of times people will try to put someone else on there, maybe their new spouse, and that's just going to cause a whole lot of family law issues and enforcement problems. So it's probably best to just be very mindful of who you make the beneficiary when that insurance policy is securing child support. When it's securing alimony, obviously your former spouse should be that beneficiary, but that doesn't come up quite as much.
And I know you and I discussed this last week when we were prepping for this, but there is no automatic life insurance mechanism, right? Isn't this something that you have to go seek?
Yes.
Yeah.
So courts aren't going to just automatically require life insurance. For those, kind of going back to our previous question, for those people who are filing their own divorces, in the Supreme Court forms, there are things that specifically say if you're requesting alimony, do you want to require life insurance to secure this obligation? You have to actively check that yes. And same thing with child support. The second part of that is you have to make sure that the person you're requesting that obligation from has the ability to secure the life insurance. And so sometimes things like pre existing conditions are going to make that a little bit more challenging. But when it comes to the forms, if you do not specifically ask for it when you file your divorce papers, you cannot get that secured by life insurance later. So, again, kind of one of those important things that if you're doing it yourself and you don't know what you don't know, you might not have thought to ask for that.
Exactly. Exactly. We can certainly talk more about this if you guys have questions, but we'll move on right now to business owners and divorce. Certainly, I see this in my practice where we'll have a husband and wife, or wife and wife, husband, husband come in, and they are owners of an LLC or a partnership or corporation. How do Florida courts determine what's marital versus non-marital property? And I might ask you to kind of define those two terms
Sure.
too, for the group.
So there's a big misconception that if it's in my name, it's mine. And if it's in your name, then it's yours. And that's not how family law courts look at it. Marital assets are anything that was acquired, created, purchased between date of marriage and date of filing the divorce. So, in situations where the business is only in my name, but I created it during the divorce, that doesn't make it just mine. That actually makes it a marital asset. And so that becomes a problem because now we have to value that. How are we going to value this asset? And a lot of people get that wrong. How much money the business earned is not the value of a business. And that is one problem when one spouse owns it. The other problem is what if it's a business we both own together? Now we're getting divorced. I certainly don't want to work with you. So one of us has to get this business, one of us isn't. And then what does that process look like? And again, how do we value it? So I know, okay, the business is worth $100,000. I'm entitled to 50. Are you going to buy me out of that 50? What does that 50 look like? So, all of the marital assets are things from the marriage. Non marital assets are things you brought into the marriage. So, those are not going to be counted or addressed when the court's figuring out who gets what in the divorce.
Okay. What are some practical steps let's talk about the business owner side of it, because that's what we're
Mhm.
talking about right now. What can a business owner spouse do to preserve a separate property claim?
So, if you really want to keep that business to yourself, that would be a good time for either a prenuptial agreement if you haven't gotten divorced, or I'm sorry, married, or a postnuptial agreement if you already are married. That would be the best mechanism to say, we agree that this is my business, and should we divorce, I'm not going to come after your business. That's going to be the best way to protect that.
And let me just say for all of you, neither Christina nor I do pre or post-nuptial agreements. This is a very niche area of law. We have people we refer to, so if that's something you're interested in, please let us know. Um, I'm a I'm a big believer in them. I don't know. I think Christina's maybe not as a big believer in them, but I certainly have seen them work to prevent arguments after the fact about what's mine, what's ours, and what's yours.
And that
Um,
comes up a lot in divorce,
mhm.
right? You have one spouse who owns the business and the other spouse doesn't. And this can happen whether it's a business owner or a W 2 employee. If the other spouse isn't contributing enough as to what the spouse who has the business feels, then maybe there's a little bit of bitterness. This wasn't your business. You didn't help. You didn't work there, but you still want 50% of that. That's not fair. And fair is a four-letter word in divorce cases, that it's just, there's no such thing. It always ends badly. And so getting your mindset right about it is half the battle.
Excellent. And in line with this from the estate planning perspective, and in most situations when I have business owners that come in to me for estate planning, married or not, they majority of the time do not have business documentation in place that would indicate what happens if, whether their partners are their wives or husbands or just Joe Schmo, they don't have documents in place that dictate what happens with death, what happens with divorce, what happens with disability. And having these things spelled out, like in a prenuptial or postnuptial agreement, will save a lot of headaches later on.
And I
Um,
think that that's the difficult part too, is a lot of people don't take the time to meet with a business attorney when they're setting up the business. Or maybe you're not sure, is this going to be a successful business? I don't know, I'm just dipping my toe in it. But then it does and it takes off. And when you don't have that meeting with a business attorney, you don't have them set up those documents. What happens when someone passes away? What happens when someone files for divorce? And then the other thing that comes up with business agreements that I do see when clients do that is, what about in the event of bankruptcy? What about in the event of an arrest? If you have a business partner or your spouse is your business partner and they've now been arrested for something that you probably don't want connected with your business, what are your options? And in divorce court, I don't know. You'd still have to buy them out of their share at a cost. And if you had business documents, if you had a prenup or a postnup agreement, that may have addressed it. So not having those really creates all of these things went really south problems that we now have to scramble to address. And I'm sure Liz and I could both agree we would much rather be on the planning side than on the reactive side of how do we fix this.
Yeah, and I think I deal with this a lot with my clients as we're planning, because I put these contingencies into their documents and they're like, well, that's never going to happen. I go, well, it's my job to plan for the
Somebody
things.
somewhere did have that happen to them, and
Yeah.
that's why our agreements are now 15 pages long.
Yes, yes. And I know we had a lot of other stuff we were going to talk about with businesses, but I, for the sake of time, I think I just want to kind of just highlight that obviously, when you have a business with your spouse and you're going through a divorce, you're going to have a lot more issues that will probably take your divorce attorney, your estate planning attorney, and your business attorney to be involved to ensure that your rights are protected, the rights of your heirs are protected. So if you take anything away from that is have those people in your toolbox, but also I know you guys are all here for this, so maybe, divorce is something you're thinking about or going through. But if it's not, then you have time to then go do these business documents that plan all these things out ahead of time, or at least as much as possible. And that's what your lawyers are for, is to think about these worst case scenarios and make sure that you're prepared for them.
And I know
Any
that one of the things I'm sure you also do, Liz, is we have to advise you on worst case scenarios because the worst case scenarios really paint the picture of how bad this could go. And so I know sometimes with my clients, they're like, "But I'm going through a divorce. How much worse could it get?" But wait. And so, that's sometimes how we show you how bad it could be by painting that dramatic picture.
Yeah. I have a scenario that I had in one of my cases recently. I think it would be good for the group. So let's say we have two people that get married, and when they marry, one of them owns a home. And part of the estate planning then would be where we're going to add new spouse to the home. The prior spouse had nothing to do with obtaining the house, purchasing the house, putting money into the house. But now they are tenants by the entirety on the house. What factors go into determining what happens with that property through the divorce process?
So there is case law that family law courts follow that say once you add that spouse to the deed, it is a gift. And now that asset belongs to the marriage. So you have just taken a completely non-marital asset and made it marital. And the burden to fight that is very, very high. And so you would then have to make all of those arguments of, well, did they put anything down? Did they contribute anything to the home? Were they able to? And so, saying that the homeowner was the breadwinner, that's not going to be enough to kind of overcome that assumption that this was a gift. And so sometimes, a lot of times, again, when do you learn this? You learn this when you're going through a divorce and you say, yeah, but that was my home before we got married. Yes, but you've now made it a marital asset by adding your spouse to the deed. And there could be maybe a better way, Liz, to do that in estate planning that doesn't muck up the deed for purposes of a potential divorce.
Yeah. And lest you think that Christina and I don't believe in happily ever after and forever love, we do. We do. We promise you, we do.
Yes.
Let me hop down to first, let me address Carol. Yes, there is a post-nuptial agreement. It's called post because it's after you got married. Um, Same essential rules apply. You have to totally divulge all of your assets and debts to your spouse. And there's a lot of other rules. Again, this is why Christina and I don't do them. But you can enter into an agreement after the marriage to agree as to what's mine, what's yours, and what's ours. Kathleen has a question. That's a great question. I'm curious how to manage inheritance during a marriage to keep it as separate asset. So let's assume that I inherit $1 billion from my mom and I'm married. Christine, I think
Congratulations.
I know. Goodbye. No, I think she's asking what can we do as the recipient of that to keep it from being ours?
Yes.
Yeah.
So the good thing is that anything you inherit is a non-marital asset, asterisk,
Mhm.
provided that you keep it as a separate asset. So what does that look like? If you inherit a home from a family member, you inherit it from your mother, and it's just to you. Great. Don't add your spouse to the deed. Now you've commingled it. Now it's a marital asset. If you receive a IRA, and you are the beneficiary of that. Keep it that way and do not add marital funds to it. Well, what does that mean? Do not add your paycheck to marital fund. Do not add money from a joint bank account. Don't add money from your own bank account. Inherit that IRA, set it aside, leave it there.
What if I
That's
use that money from the inherited IRA for a family vacation?
then that's marital money. So whatever you took out and put into to use for marital purpose or during the marriage, marital money. And some people say, well, what if I take money out of that inherited IRA and go on a trip with someone not my spouse? It's still marital money because it was used during the marriage.
Mm.
Whatever stays in the IRA would still be inherited and non-marital, but you have to keep it aside. Has to be its own. If you receive, maybe you receive a smaller inheritance, it's $20,000. You receive it, you put it into a joint bank account with your spouse, poof, that's now marital money. And you
Yeah.
can't say when you go to get divorced, I want to carve out that 20,000 or I want my 20,000 back because it was inherited. Once you mix it up with other marital money, it's not non-marital. I wanted to watch out for the double negative. Once you mix it up with other monies, it is now a marital asset. So the best way, Kathleen, to have that inheritance separate is to always keep it separate. Don't add your spouse, don't add marital money, don't mix it up with anything else.
Yeah. And on that same line, you've inherited it. You're doing all this work to keep it as separate. You want to make sure that you have some estate plan mechanism, whether that's beneficiary based or trust based or whatever, to get that money to whomever you want it to go to. It must not be the spouse. So whether you want it for your children or your own side of the family, which happens all the time, you want to keep family money with that side of the family. You want to make sure you then talk to your estate planning attorney about how best to do that. Let us know if that didn't answer your question, and we'll talk about it some more. Any other questions? We've got about 10 minutes left before everybody has to get back to work and everything. So feel free to come off mute or throw it in the chat. We'll hang out here for a little bit, see if there are any other questions. In the meantime, Kristina, any final thoughts?
Well, I was going to ask, from your perspective, how how do you advise clients? They've gotten divorced and now they're thinking about, well, who's going to take my spouse's place
Mhm.
as my healthcare surrogate? How do you talk clients through that? I mean, they've just come off a divorce. They're probably still pretty emotional. It's still pretty raw, but they're in your office. How do you talk clients through that new decision process?
Yeah, I think it's the same way I talk anyone through it who doesn't have a spouse. What's the criteria we're going to use when we're talking about someone that's going to make decisions about paying your bills, someone that's going to be able to access all your financials, someone who's going to be able to make life or death decisions for you. So oftentimes that can be an adult child. Sometimes they're not the best options, but sometimes it's the only option. Sometimes we do professional fiduciary. We'll talk about that option. Kathleen, who's on the call, is one of those professional fiduciaries that we suggest clients talk to see if that would be a good fit for them. But when it comes to having that discussion when they're going through the divorce or just after the divorce, it's really just our job to give them all their options and tell them this doesn't have to be a permanent decision. This can be the placeholder decision while life gets back to a new normal for you.
That's a
So,
good point. I mean,
mhm.
in terms of advising clients, I love the opportunity to chat with other professionals, whether that's an estate planning attorney or the business attorney, to make sure that we're all on the same page. And I'm sure Liz would agree that the planning side is better, and we're happy to work with other professionals regarding that. And so, if you don't have that person or you're not sure who that attorney could be or should be, even though Liz and I don't practice in those areas, fun fact, we're friends with other attorneys. And so we have colleagues that we trust and work on cases with and refer cases to. So we'd love to have the chance to coordinate the best plan for our clients.
Absolutely. Question from Karen. Do your healthcare surrogates or power of attorney designations have to reside in Florida? That answer is no. The only fiduciary that has a residency requirement in Florida is your executor, your personal representative in the will. That person either has to be related to you or live in Florida. They don't have to be both. They can be your cousin who lives in Timbuktu, but as long as they're your cousin, they can serve as your personal representative. But for those other roles, power of attorney or healthcare surrogate, they don't have to live in Florida. I talk to my clients about what the practicalities are, though. If they're far away and they don't do email or have a smartphone, that might be a little bit more problematic than someone who's local. But there's certainly no legal impediment to them serving. Um, any other questions before we wrap it up? I want to thank Kristina for being here. Kristina, if you wouldn't mind putting your info in, she's a step ahead of me. She already got her info in the chat if you wanted to meet with her about her practice areas, which again are predominantly family law and bankruptcy. I do want to thank you for being here, Kristina. I appreciate it. I think it was some good information. Next month, I'm going to be talking about how to pay for long-term care when it comes to Medicaid planning. October is revocable living trusts. November will be Medicare. So how to deal with open enrollments and just getting into Medicare for those of you who are in your, 65 plus years. And then in December, we're going to talk about incapacity planning. So powers of attorney and living wills, that type of thing. We are planning 2027. So if you have subjects you'd like us to talk about or experts like Kristina you'd like us to have on, please let us know. You can just shoot that in the chat or shoot us an email at any time. So anyway, thank you all for being here. If you have other questions, you have Kristina's information there. You can get my information from Vicky's email to you, and we'd be happy to help. So everyone have a
Thank
great
you.
day.
Thank you.
Absolutely.